everyone, this is Norm Odeneal with Keller Williams Realty, and today I've got a great guest joining me. I've got Kathryn Swain with McCandless. She is a local attorney. We're going to talk about probate, estates, something that comes up a lot in my real estate work. Kathryn has a ton of experience in this area, and I'm really looking forward to the conversation. Let's jump right in.
Norm, I'm so
Yeah,
excited.
definitely. Take a minute and introduce yourself.
I'm Kathryn Swain. As Norm said, I'm an attorney with McCandless and Lillard. We're in Fairfax and Leesburg, Virginia, but I do estate planning, estate administration, which is the post-death work, and then guardianships, conservatorships for incapacitated adults.
Wow, that is a ton. Thank you. Can you tell me a little bit about how estate planning and probate differ, or what is the difference between that?
Estate planning is really the before, and probate is the after, depending on if an estate goes through probate or not. But estate planning is what we're hoping to do before the individual passes away, where they're setting up either a will, a trust, even their powers of attorney for their during life decisions. And then probate is the process that happens after someone passes away. And we'll get into it a little bit more, but if a person has probate assets, then their estate has to go through that probate process. There are ways to avoid having probate assets and even going through probate.
I know people will be interested in hearing about that. Can you tell me a little bit more about why it's important to have these conversations before a crisis or a passing happens?
Well, really at that point, it's too late. So at that point, we're just picking up the pieces. We're trying to come away with something when the plan wasn't in place to begin with. And a lot of times that can lead to family issues, conflict in the family. A lot of times there's extensive legal fees if, there has to be a trial on what the person intended because they didn't set up a good plan to begin with. So even though these conversations are difficult and, a little bit morbid to come into an estate planning attorney's office and plan and speak about your death, it's really so necessary to do that before anything happens, because then you can put it aside. You can stop thinking about it. You've got your plan in place and it's kind of off your shoulders.
That's also got to be a relief.
Mm-hmm.
Tell me a little bit about the real estate connection, because a lot of my clients that I'm helping, they have a piece of real property that needs to be sold. And can you tell me how that works in Virginia? Like when someone inherits a home in Virginia, what's the first legal step they should take?
So the first step would be for them to look at how that property was titled during the decedent's lifetime and how it's titled now. Partly they're going to be looking at whether they were a joint owner with the decedent, and if they had rights of survivorship, they may take over as a matter of law and be the sole owner at that point. In Virginia, we have something that sounds kind of silly, but it's called the drops like a rock doctrine. And it's only with regard to real estate, not personal property, but it means that property transfers at the moment of death to either the beneficiary or the heir at law. So ownership transfers right then, but there are other steps that usually either the executor or the other personal representative has to take in order to, codify that and make sure it's clear in the land records that the property ownership has transferred.
Quick question, how long would it take to follow up and make sure that the transfer happened in the timeline you described?
A lot of that depends on how the planning was done. So if there was something called a transfer on death deed in place, that's a great scenario, because that means that when the person passed away, the property transferred as a matter of law to whoever they named on their transfer on death deed. Another option could have been for planning purposes to put that real estate into a trust. If the decedent had a trust in place, that also means the property transfers according to the terms of the trust, and we're not dealing with the probate process in either of those scenarios. But if there's no plan that was done, then we have to consider what steps need to be completed in order to transfer ownership. A lot of times that involves filing a real estate affidavit with the probate division, updating land records, getting deeds of confirmation in place so that it's very clear that the new owner is the true owner at this point.
The true owner, that makes a lot of sense. That sounds also like a lot of steps. If someone has to go through a kind of a probate process, how long would that take?
The entire probate process can get a little bit extensive. It completely depends on family dynamics. If there's a lot of conflict, or there was a will that's not very clear, or maybe there was no will at all, that process can go all the way up to 16 months, even years, depending on if there's a trial going on or it's really gotten contentious. But again, if there's planning in place, things can go much smoother. So usually if there's a plan in place, there's either a trust or there's a will that's being probated and the estate is active, under a year, the probate can be completed. And sometimes it's only open, that estate is only open for up to a year because the executor is being very careful, waiting for creditor claims, any debts that may come in, making sure taxes are paid. And it's not that they're necessarily, doing a lot of distributions that whole time. They're just being careful of making sure they've waited enough time.
That makes sense. They're being careful. During that period, could the heirs or whoever's taking the will forward get the authority to sell the real estate?
Yes, absolutely. So the executor under a will can sell the property if that provision is in the will, if there's a power to sell real estate. Same thing with the trustee under a trust. As long as that power is in a trust, the fiduciary can go ahead and begin sale. As long as the trust doesn't say something or the will doesn't say something, to the opposite effect. So if it says that that property should go to the beneficiaries without sale, then of course it needs to be distributed in kind the way the terms spell out. If there's no will in place at all, then the individual qualifying is called an administrator, not an executor. And the administrator doesn't automatically have the power of sale over real estate because there's no will in place that gave that power. So they would have to go to court and actually ask a judge to sign off on them having that power. So usually that's only necessary if the administrator needs to sell the real estate because there are other debts in the estate that need to be paid for from the proceeds of that sale. Otherwise, we go back to what I was talking about, that kind of silly doctrine or silly sounding doctrine that drops like a rock doctrine, that immediately transfer happens and that transfer is made to the heirs at law. So if there's no debt in the estate, there's nothing that needs to be paid, then the administrator may not need to sell the property as an administrator, but instead the property would pass to the heirs at law and then they could sell the property themselves.
The heirs would sell it.
Exactly. And then they would just be owners of the property. So they wouldn't be selling the property in a fiduciary sense. They wouldn't need court approval. They would just be owners like any other, owner of real estate, and they could sell the property themselves. Of course, in that case, if there's multiple heirs, they have to come to an agreement on those proceedings, which is in itself, but separate from the probate process.
When you're sharing that and I hear, multiple heirs, potential siblings, it sounds like that could slow down the process if you're dealing with just the more people you're dealing with. Is that what you found?
Absolutely. Unfortunately, money and debt brings out the worst in people. We do see a lot of conflict. We see a lot of litigation surrounding that. And the best way to avoid that is really just to have a clear plan in place to begin with. And if there is a clear plan, then often one person is appointed as executor or administrator of the estate. And so in that case, that person is the one who has the authority to make those decisions. And even if everyone else disagrees, they don't have the power to dictate what happens. So that makes it a little bit simpler. If multiple people are named and they're fighting, or if that property has passed to heirs because there wasn't a plan and they just have to sell the property, as the new owners, there can be so much conflict, and that really does slow down the process.
Gosh, I can imagine. We could probably do a video just on that.
We could talk for hours about all the estate conflicts.
I bet. Well, tell me some more of the challenges maybe outside of that particular one, like common challenges families face when they're trying to sell an inherited property.
One of the things that people forget to do when they're selling in a fiduciary sense, meaning that they're an executor of an estate or a trustee of a trust, is often they forget to get an appraisal of the property, and that should be done as of the date of death. So a lot of times appraisers will backdate if you ask them to, and if they have comparable values to assess, to at least very close to the date of death. It's important for multiple purposes. So if the fiduciary sells the property and say this has become a hoarder property, it's not in a good condition, and it's not going to sell for the tax assessed value that the county has set, then that fiduciary has to show that they sold it for the top dollar that they could get. It just wasn't in the right condition. And so they can't compare the value of sale to the tax assessed value because then they're going to be much below it. So an appraisal helps show that yes, maybe the structure looks great. The county says that this is worth a lot more, but when we get inside, there's an insect infestation or rat infestation, there's hoarding, there's damage, whatever the case is. And that really does change the value of the property. The fiduciary has a duty. They have general fiduciary duties to the estate, whether it's, an executor to the estate, a trustee to the trust. And so they can't just decide on their own, I'm going to sell this property for $100,000 less or $200,000 less than it's worth unless they can prove that. So that's where the appraisal comes in, and people forget to do that, or they're not thinking of it. The other thing that can really be helpful with an appraisal is that it determines the tax basis for that property as of the date of death. And one of the things that's important there is that if property is transferred during someone's lifetime, there's no step up in tax basis if it's just a gift one person to another, during lifetime, if a father gives it to his son. But if the father passes away and the son inherits that property, there is a step up in tax basis. And so the appraisal helps to determine what the value was as of the date of death.
I love that you brought that up, because stepped up basis is a question I have coming up for you. So maybe we get into it more, but I think it's a huge gain, a huge point you just made on how families can protect themselves on how property transfers.
And I would just say the other thing that is sometimes forgotten, and another pitfall that people fall into, is not documenting properly everything that they're doing along the way, not really keeping records of fiduciary actions when they're selling the property. So that's important too, just to keep everything completely documented, keep receipts the whole way.
Yeah, you said it. That's part of my job too, is keeping all these documents, things in order. I enjoy helping families in this type of situation. So what are some of the other challenges you've seen, or maybe what's the biggest mistake people could do when handling real estate through an estate?
Well, one mistake would be to sell the property using a general warranty deed. So a lot of people, when they're stepping into this position, they may never have lived in that property. Maybe this is a family member or even a friend, and they don't have personal experience with that property to claim that this, should be completely warranted, that the condition is great, and that someone can move in and not have any problems. So what we suggest is to do what's called a special warranty deed, where they're not doing, a general across the board warranty for the condition, and to also make sure that the property is conveyed as is. So if there is damage, whether it's known or unknown, that person's not being held liable and responsible for it.
I love that you brought that up. It's not something I hear about every time when folks are transferring property, is the type of deed they're using. And I know we both would love to talk more to our clients about that and make sure that they're protected in that area. You mentioned the stepped up basis earlier. I think a lot of folks may not know what that is, especially someone who, just inherited some real estate. So what should heirs, administrators, executors know about capital gains and stepped up basis, the tax implications when they sell a property?
Well, real estate is subject to capital gains taxes, and capital gains taxes will be based on the value at the time the sale is happening versus the time of acquisition. And when somebody purchased a property, especially in Virginia, in the Northern Virginia area, where real estate is just shooting up in value often, you may have purchased property in, Arlington County or some of these really known to be expensive counties now for something like $15,000, $20,000. I mean, the numbers are kind of shocking when you know what the values are now. And some of those properties are worth over $1 million, sometimes $2 million, $3 million at this point. So there's been a huge change in value. And in that scenario I was mentioning previously, if someone gifts property during lifetime, the receiver of the gift gets that original $10,000, $20,000, $30,000, whatever the original purchase price was. That's their tax basis. So they would pay capital gains on their sale, which is now, $2 million from the difference from the original price. If they instead receive the property in an inheritance, then they get the date of death value as their step up. So they get that stepped up $2 million value as their starting point. And then when they sell the property, say they sell it within 6 months, probably the value hasn't changed too much, and they're paying very little, if any, capital gains on that difference.
That is just such a huge selling point. Literally, it's a huge advantage for people who are going through, a lot of tough time. There's a lot on their plate. Here's some good news on the stepped up basis piece.
Absolutely. And it's a good warning, because some people, if they feel their health is failing, they really want to make things easier after they pass away. And they think, let me just sign this over to my daughter, my son, who's helping me now. And it'll just make it so much smoother because they'll already be the owner. But that's a huge, roadblock to that. And we want to make sure that that doesn't happen during lifetime, unless there's some other reason for it that outweighs the capital gains, tax problem. But otherwise, we want to caution people to do that transfer only after death, so that they do get that step up in tax basis.
God, I love it. I love it. You're looking out for your clients. This tax implication is a huge one. We're talking numbers in the millions. You're able to help them avoid that. That's fantastic.
Absolutely.
Remind me again then how long does the probate process typically take in Northern Virginia? And then how does that impact, when a home can go on the market?
The probate process, I would say on average, goes close to a year. Around 9 months would be one of the shorter timeframes, and going up to over 2 years, 3 years if there's contested litigation or anything like that. But as soon as the executor has the power of sale, they can begin selling the property even while that probate is going on. So this is, again, if the will has given the executor the power of sale and that executor has actually gone to the probate division and qualified, not just, taken the will and decided to start acting. They do have to take that up and actually qualify with a probate clerk, but then the executor can begin. If the will isn't in place or it doesn't authorize that sale, then they would first have to go to court to get that power of sale before they can start the actual sale of the property. But once that's done, they don't have to wait till the probate proceeding is concluded. They can do it while that's all ongoing.
Fantastic. That's got to be good news. Switching gears just a little bit, I'd love to, talk with you a little bit about estate planning and estate planning for homeowners, because part of this is what I'm hearing you say is so important to communicate with your attorney and get these plans in place before an event. And for homeowners that have lived in their home, say like 30 or 40 years, what documents do you recommend that they should have in place to make things easier for their family later?
Well, for any person, we'd want to make sure that they have a will or a trust in place. That's the document that's actually going to dispose of property after death and determine where property goes. We would also suggest that anyone over the age of 18 should have a durable general power of attorney, which is the financial power of attorney. That exists during the person's lifetime, and it appoints an agent to step into their shoes, make any decisions with regard to their finances and assets on their behalf if they ever can't. And then also an advanced medical directive or healthcare power of attorney, which allows them to appoint an agent to make those decisions for healthcare purposes. If that person's also a homeowner, then they certainly want to specifically plan for their real estate as well. So they can do that within their distribution document, either the will or the trust, where they specify who gets that property. If they set up a trust, they'd want to make sure that they actually move their real estate into the trust after they set it up, because otherwise the trust is kind of just an empty bucket for assets where nothing's, in there to be passed according to the terms of the trust term. So when we're setting up an estate plan for someone, we can create that deed that moves their property into their trust, and then it can go according to the terms that they set up. If someone instead has more of a will-based plan or a plan that doesn't involve a trust, we would suggest that they do a transfer on death deed, and that is something that avoids probate. It gets that property to the person who's named on the transfer on death deed as a matter of law at the moment of death. So both of those things provide for the passing of the property after death. With the financial power of attorney and other similar documents, they can also provide for someone to step in and make decisions about that real estate if they're alive but have lost capacity and something needs to be handled with regard to the property.
Wow. As you're saying that, it feels so like everybody needs this,
Absolutely. Yeah, it's something, unfortunately, it's coming for all of us. So all we can do is plan, get a great plan in place, and then again, not have to think about it again.
Yeah, these are the kind of things you don't really want to think about at all. So it helps to go through it with a professional and then get through it as fast as you can, maybe.
Absolutely. And there will always be updates in the law or updates in someone's family that may trigger changes and reassessments to the plan. But generally, once it's there, it's not something that needs to be dealt with, at least on a regular basis.
Yes. That sounds like a relief.
Absolutely.
We've talked about wills and probates. Can you tell me a little bit about a trust? What is the benefit of a trust, and maybe how is it different than maybe a planning by will?
So one of the big differences is that assets that pass through a trust do not go through probate at all. But wills, if there are probate assets, meaning there are assets just in that individual's name, so not owned with somebody else with rights of survivorship, not an asset that has a transfer on death designation, like payable on death or TOD. If it's just in that person's name with none of those designations, that's a probate asset, and it will go through the probate process even if a will is in place. And what we were just talking about is, the downside to probate. It can be lengthy, there are probate taxes and fees, and whoever is appointed to deal with the estate under that will has to do regular reportings to the county commissioner of accounts. So they would file an inventory, they would file regular accountings. All of those filings have have fees associated with them, and they're really not user-friendly or easy to understand, how to create those inventories, how to create those accountings, what forms to use, how everything should be laid out. So it's a really difficult process, especially when a loved one is grieving you and they're trying to settle all of your affairs and then do this court, process. In Virginia, we don't have a separate probate court, but the circuit court does supervise the probate proceeding, and the commissioner of account ultimately supervises how an estate is managed. But on the trust side, as long as the trust is properly set up and assets are placed into the trust, we call that funding the trust. If the assets are moved into the trust during the person's lifetime, then they pass without any of the need for that probate procedure. So the individual can set up whatever bells and whistles they want on their trust. For example, if they have minor children, they may want to hold distributions for those minors in continued trust till they're 18 or even 21, 25, whatever age they feel is appropriate, because sometimes we're mature enough, whether it's age related or for another reason, to actually deal with that. So that's one of the major differences. The other difference is that trusts are set up and funded during the individual's lifetime. So if that person ever loses capacity, even though they're still alive, their successor trustee can jump in and manage the property for them so that they don't have to go through a court proceeding for guardianship and conservatorship, which is a public declaration of the person's incapacity just to get a decision maker in place, for the judge to approve. So it really does make things simpler on both the incapacity and the after death side.
I see what you're saying. If you value your privacy and things of that nature, this is a great step, as life happens.
Because the probate procedure is all public. So any will that's being probated can be looked up. You can see exactly who got what property. And a lot of people are uncomfortable with that if they have minor children, if they have special needs beneficiaries, or if they just don't want that, publicly available with all of the scammers and the AI issues we have today.
Oh my God, you said it. You said it, Kathryn. As you're talking too, I was curious if a property passes through a trust and then the trust sells it. Does the stepped-up basis come into play there, or?
Yes, so as long as the property is transferred after death, then it's a non-issue. And a lot of people set up what are called revocable living trusts. They put their property into the trust during their lifetime, whether it's their personal property or their real estate. And then at death, that transfer happens where the beneficiaries that they've named receive the property, and they've got that stepped-up tax basis as of the date of death of the original grantor of the trust.
Oh, I love that. So even if it's in a trust, you still get the stepped up basis.
Absolutely.
Got it. Just so I know, or I'm sure a lot of people are curious, once you put something in a trust, like you put your real estate in the trust, and let's say interest rates come down and I want to refinance, does that make it more complicated that now my home's in a trust and I want to get maybe a refinance started?
There's actually a law in place that governs this. It's called the Garn-St. Germain Act. And that says that you're not required to pull that property out of the trust, to sell it, to refinance it, to do any action with it. So it should be completely streamlined, and there shouldn't be any complication with having the property in the trust. With that being said, everyone's dealt with a difficult, company, closing company, title company, whatever it is.
Yeah.
And if the property for their purposes needs to be pulled out of the trust for a sale to happen, it's an easy deed of distribution to pull it back out. But otherwise, the property would be dealt with as trustees. So the person managing the property or managing the trust is called the grantor. They set up the trust. It's their own property. They're also the trustees of the trust. They continue dealing with their property as they normally would. They're just signing off as trustee on any transaction they make.
Oh, that's great to hear. Tell me about this. How can a realtor and estate attorney like yourself work together to make sure a client's home sale aligns with their estate plan?
Well, first of all, the estate planning attorney could advise on what the documents actually say should happen with the real estate. If we're in that scenario where the administrator doesn't have power of sale and the property needs to be sold, then the attorney could help to get that authority from the judge, in a court proceeding. But also the attorney can work with the real estate agent to make sure that those provisions we talked about are actually in the documents, that the property is sold as is, that there's a special warranty deed, that all of that is in place so that the individual is not taking on more liability. Because this is something that some people don't ever do, even in their personal lives, to sell their own property. But certainly a lot of people don't take action as a fiduciary and sell property out of an estate just every day. And so to have kind of that peace of mind that there is not only an attorney, but a real estate agent also working together to safeguard their interests and make sure they're completing the proper steps is huge.
I couldn't agree more. I couldn't agree more. I'm sure you see it all the time. When we're working with our clients, they have so much of life happening and so much of it is new to them that it's really nice when we can walk alongside them and take something off their plate or just smooth out a rough edge and allow them to move forward with their day.
Absolutely. And sometimes people are appointed who don't even live in Virginia. So they may be in their state. They're trying to deal with, again, their own life, but then they have to deal with Virginia law, Virginia procedures, fiduciary procedures. I mean, it's a huge burden to take on. And so having trusted resources is very ideal.
I love the way you put that. Trusted resources. Exactly. Tell me a little bit more. At what point should someone call an estate attorney, a probate attorney? And when they do call, what should they have ready?
Well, on the planning side, before someone has actually passed away, really anyone over the age of 18 should get these documents in place. Even, college students to have durable general powers of attorney and advanced medical directives in place so that when they go to college, they can appoint their parents to deal with their assets as necessary, even though they're farther away. And then as people become, young adults, they start families, they need to have a plan in place for what would happen if they leave minor children, who would be the guardians, how would property be transferred to those minors since they can't legally inherit things outright in their own name. And then certainly as someone becomes, an older adult, especially if they're suffering with any health conditions, we would want to have a plan in place while that person still has capacity to sign any documents that are necessary. After there is a loss of capacity, if that ever happens, that's when we get back to the guardianship or conservatorship proceeding in court, which is public. It costs a lot more money. It's not something anyone wants to go through. So really, there's no perfect time except just doing the estate planning early enough, and at every stage it's appropriate. On the probate side or the after death side, when someone is dealing with an estate administration, I think it makes sense to immediately speak with an attorney and see what needs to be done, because it could be as simple as the attorney telling that person all of these assets were jointly titled or all of these assets had beneficiary designations, and we don't have to do a full probate proceeding, so you can handle this on your own and give you steps X, Y, and Z to complete. But then you have the peace of mind that you know exactly what to do. And if it is a more complex meeting, you'll have that guidance the whole way before you take a wrong step and actually, maybe create a fiduciary issue or, just have a misstep basically that gets you into trouble.
That makes sense. As you're speaking, I can just hear how important it is to be in good communication with you so that you know exactly what's going on in your clients' lives, and then you can adjust the documents to benefit them as they mature and get, go through life.
Absolutely. And so much is always changing in everybody's lives. If they have children, those children are growing up and may have different needs for how their distributions are managed, whether they're in trust or not. And then those children may get married, and maybe there's a spouse that the parent doesn't like, a son-in-law or a daughter-in-law. They want to make sure their property is protected for that purpose. And then maybe there's a divorce and they have to remove someone from their documents. So there's always these life changes, but we can keep up with that, and we can keep up with the law changes, Virginia law changes or federal law changes, if you stay in touch with an attorney and meet those issues on the front end rather than leaving that mess because it's complicated and you don't want to deal with it, and then suddenly we've got a huge issue after death where all of those things are wrong.
Oh, that makes sense. The time to get ahead of it is now.
Exactly.
Yeah. Can you give me an idea of what it typically would cost to set up an estate plan or to handle a probate case?
An estate plan, it's a lot cheaper than dealing with a probate case gone wrong. So a lot of people don't want to spend the money up front. They either want to have, nothing in place, or they want to download a free will template on the internet.
Sure.
And usually those always end up, something is either, contested and we have litigation, or something was misconstrued and we don't have the person's intent. So then we have litigation as well. On the front end, it completely depends on the person's circumstances, whether they're married and this is a family plan or a single individual. But it can be anywhere from $2,000 to around $5,000, depending on complexity. I would say that's a general range. We can go, above or below based on that person's needs. But if there's estate litigation and the matter has to go to trial, this can get up to $25,000, $35,000 or more easily. And that's assets that are coming out of the estate. So it's much better, although it always hurts to spend that money, on the front end, but to get a good plan in place so that you're not spending much more on the back end.
Yeah, it sounds so preventative. You're going to save money on the back end. You're also going to save time, headache, grief. That makes a lot of sense. What are some of the maybe a couple red flags that someone might be heading in for a difficult probate situation?
Sometimes we see family conflict that's manifesting before an individual has passed away. So maybe one of the parents is declining in capacity, and maybe that person has even remarried. So we've got family complexity. Maybe there are stepchildren who are pulling the individual in one direction or another. And that's where, as an estate planning attorney, I really want to evaluate whether that person has full capacity to be executing new documents, or whether those documents might be contested later on because they didn't have full capacity. And then also, even if they do have capacity, whether they're being unduly influenced by someone like that, whether it's a stepchild or another family member who thinks they can manipulate the individual. And often those things are immediate red flags when we see someone come in, with that person, whether it's their parent or whoever the family relation is, but we see them sort of being pushy with the decision making and trying to interpose their own will. And then we know that there's potentially going to be something contested down the line, especially if it's not handled properly before the individual passes away and there hasn't been an evaluation of capacity or that undue influence issue.
It makes a lot of sense to me. Again, you have so much expertise in this area. This is very helpful because you can almost see it before the client sees it, or you're able to see it and give advice and get out ahead of it. It's very welcomed.
Thank you.
Yeah. Yes. Tell me about this. If someone wants to get their affairs in order but doesn't know where to start, what's your advice?
My advice is just to pick up the phone and call to set up an appointment with an estate planning attorney and see exactly what needs to be done, because it may be something that you're really dreading and you think it's going to be much worse, maybe more expensive or more involved than what it is. And you may have an estate that doesn't require as much of that, but you'll have that peace of mind of getting a plan in place if you at least sit down and meet with an attorney and talk through what you may need.
Oh, that's perfect. Yeah, just start with a simple phone call. You want to hear what's going on and how you can help.
Exactly.
Yes. What's one thing you wish every homeowner knew about estate planning?
I would say that non-action is an action. And so by waiting and by thinking, well, I don't know what to do with my real estate, I don't know who should get it, or I don't know how to set that up, you're actually taking an action. You're leaving this open to a bunch of problems down the line, potentially. So it's kind of like going to the dentist, going to the doctor. Things off the to-do list, and they may be uncomfortable or not the best thing on your schedule that week, but taking that action is really the first step, and it's so important with an asset as valuable as real estate.
My gosh, that's fantastic. Thank you. How could people find or choose a qualified estate attorney?
The biggest thing would be to look for experience in estate planning and estate administration as either a sole focus or a major focus. A lot of attorneys do, across the board work. They different areas. They may not specialize in estate planning or estate administration. So find someone that you're confident in the experience level that they have and the knowledge base they have. And it's completely okay to interview multiple attorneys, and speak with different professionals, have consults, and go to someone that you really trust who's going to keep your issues at forefront and not just be trying to sell you a plan.
Really get to know you and learn what you're trying to accomplish here.
Right.
Specialize too.
Exactly.
Love that. So, Kathryn, tell everybody what's the best way to get in touch with you, and are you on email, or what's the best way for people to reach you?
Absolutely. So I'm sure we'll post my information here. My direct line is 703-934-1111. Easy to remember. So feel free to call me, and also email. My email will be posted, but I'm happy to talk to new clients all the time. I don't charge for consultations. I want to be able to give that information and have the person, discuss it and evaluate it and not feel like they're up against the clock when they ask me questions.
Kathryn, just by you saying that makes me want to call you, so we can, this is exactly what our clients are looking for. Professional advice, and it kind of on their schedule almost.
Exactly. Yes. This is a personal thing. It's something that someone needs to fully understand and completely agree with, and not just get a pile of legalese, whether it's a trust or a will, but some document that they don't understand and it may not reflect their true intentions. So it's really important to me to sit down and meet and talk through all of their family, relationships, all of the issues that they're trying to plan for, and then come up with the best approach that's really going to suit them.
Oh, that's great. That's great. That's why you're doing an excellent job for your clients. I appreciate you being here and joining me for this video today. It's been super informative for me. I know that so many folks have been looking forward to the video, so I'm looking forward to sharing it with them and getting this good information out there. I'm Norm Odeneal, local realtor with Keller Williams Realty. Remember, questions, concerns, hallucinations, call Norm.